Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. We did promise that during the PEPT Presidential Election Petition Tribunal that the next stage will be the final written addresses to start with, of course, APC, Bola Ahmed Tinubu and Shetima. Then 7 days after, Labour Party will be responding, and subsequently, then eventually, the judges will give the final verdict. Well, as I speak, Tinubu Shetima have decided to give their verdict, their own final written address, and we're going to give you full details on that. Before we do that, kindly subscribe to our channel by clicking on the right subscribe button. Beside it, you'll see a bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube, where the President Bola Ahmed Tinubu and Vice President Kashim Shetima have given reasons why the Presidential Election Petition Court PEPC should dismiss petitions filed by the People's Democratic Party, PDP, and the Labour Party LP and their presidential candidates Atiku Abubakar and Peter Obi. The report has it that Tinubu and Shetima insist that claims that a candidate must score 25% of vote in the Federal Capital Territory FCT to be declared president could have been a result of either their misreading of the Constitution or their miscomprehension of the relevant provisions of the nation's ground norm. It was gathered that these submissions were part of the argument in 2 sets of final written addresses filed on the petitions by Atiku Abubakar and PDP and Obi and Labour Party against the outcome of the February 25th presidential election. Well, according to the news, the 2 final addresses were filed on Friday by Tinubu Shetima legal team led by Wole Olanipekun, senior advocate of Nigeria, and describing both petitions as strange and hollow. Tinubu and Shetima argued that neither of the 2 sets of petitions provided relevant evidence to support the claims of the plaintiffs that the election was not held in compliance with relevant laws or that the presidential and vice presidential candidates of the APC were not qualified to contest the election. The defendant said the suits could not even be considered as petitions within the context of the nation's electoral laws, as they were strangely not complaining about election rigging, ballot box snatching, ballot box stuffing, violence, thuggery, vote buying, voters intimidation, disenfranchisement, interference by the military or the police, and such other electoral vices. The crux of their gross is their petitions is that this time around, while the presidential election was peacefully conducted all over the country as corroborated by their primary witnesses, that is, the presiding officers, that's POs, and the result accurately recorded in the various Form EC8As, some unidentified results were not uploaded electronically to INEC Election Result Viewing Center, that's IRF, viewing portal, that's IRF, Tinubu and Shetima said. Continuing, they said, and I quote, "The other remote contention of the petitioners is that the second respondent, Tinubu, did not score 25% or 1/4 of the votes recorded in the Federal Capital Territory, Abuja, FCT, while the petitioners have also tensely alluded to the respondent non-qualification without providing any fact of same in the body of their petitions. They submitted that the petitioners failed to establish their claims with adequate and relevant evidence as required by law." Tinubu said he won the election with 8,794,726 votes ahead of Atiku Abubakar PDP, who were his closest rival, though trailing at a distance with a total of 6,984,520 votes. And Obi Labour Party came a distant third with a total of 6,1 101,533 votes. Besides, the defendant said while they polled more than 25% of the total vote cast in 29 states, Atiku secured the same in 21 states, while Obi got 25% in only 16 states and the FCT. They added that it was ironic that while Atiku, who scored 16.13% of the vote cast in FCT as against Tinubu's 19.76% score in the same territory, it is not only seeking to be declared the winner of the election, he also wants Tinubu's victory voided on the grounds that he, Tinubu, did not score 25% of the vote cast in FCT. Citing previous decisions of the Supreme Court on the status of the FCT, the respondent said there is no pronunciation. I take that again. There is no punctuation, which is like comma, in the entire section 134, subsection 2b of the Constitution, particularly immediately after the states and succeeding and connecting the Federal Capital Territory with the state. In essence, the reading of the subsection has to be conjunctival and not disjunctive, as the Constitution clearly makes it so. Pressed further by the constitutional imperative, the Federal Capital Territory Abuja is taken as if it is a 37th state under and by virtue of Section 299 of the Constitution. With much respect, any other interpretation different from these will lead to absurdity, chaos, anarchy, and alteration of the very intention of the legislature. Our courts have always adopted the purposeful approach to the interpretation of our Constitution as amplified in a host of decisions, including but not limited to Nafiu Rabiu versus State 1980, 12 NSCC 291 at 300 to 301, Mawa versus Inyako 2012, 6 NWLR bracket PT 1296 199, 306 to 307, then ADH Limited versus AT Limited 2006, 10 NWLR .986 6307 649, Awolowo versus Shagari Supra, Abraham Adesanya versus President, Federal Republic of Nigeria 1981, 12 NCC N146 at 167 to 168, AG Abia versus AG Federation 2002, 6 NWLL PT 763, 265 at 365. The petitioners themselves admit this much in paragraph 107 of their petition, where they listed the FCT as the 37th state after listing the states mentioned in section 3 subsection 1 as numbers 1 to 36. According to Tinubu and Shettima, it was an irony that the LP candidate who came a distant third in the election wanted to be declared the winner of the election. The respondent stated that the Obi Labour Party petition was hinged on frivolous claims that the election results were not electronically uploaded on the RF, that it was not conducted in compliance with the provisions of Electoral Act 2022 EA, and that the Tinubu-Shettima ticket was unlawful because Shettima was not properly nominated. They added that Atiku and Obi also based their petition riddled with contradiction and conflicting claims on some fishing expeditions relating to some purported forfeiture proceedings in the United States of America, US. They faulted the petitioners' claim about the qualifications of Tinubu and Shettima, arguing that not only did the petitioners fail to prove their allegations, both respondents provided ample evidence to establish that they were eminently qualified to stand for election for the office of the president and vice president. Tinubu and Shettima added, largely, the election went very peacefully, under a free and fair atmosphere, without proof of violence, ballot box snatching, and as such, other electoral irregularities and vices, a state of affairs to which the petitioner witnesses all testified. In fact, the election was conducted in substantial compliance with the principles of the Electoral Act, the INEC regulations, manuals for the election. Coincidentally, a host of witnesses called by the petitioners corroborated the unstable and or unpredictable nature of technological devices applications within the Nigerian terrain. Tinubu and Shettima argued that both petitions are not only without any form or substance, but repetitions and contradictions and confusion also characterized them. The respondent noted that the petitioners clinically alleged non-compliance with the provisions of the Electoral Act on the flimsy ground that the polling unit results were not electronically transmitted and uploaded on the RF where collation did not take place. Their witnesses admitted that manual collation took place from the polling unit level to the national level. They added that while the petitioners claimed that Tinubu did not emerge winner with the highest number of lawful votes cast throughout the petitions and during the trial, at no portion did they state that they considered as the lawful vote cast for both parties and the number of unlawful votes added to the respondent on the number of votes unlawfully deducted from their own vote. While describing the evidence by the 27 witnesses called by Atiku and PDP and the 13 called by Obi and Labour Party as unreliable, Tinubu and Shettima argued that their sole witness successfully established their case. They added that their sole witness, Senator Okpeyemi Bamidele, the Senate Majority Leader, demonstrated undoubted competence to testify in respect of the subject submitted before the court, including issues surrounding U.S. proceedings, himself being a U.S. practicing attorney and counselor at law. Also, being a lawmaker who participated in the enactment of the Electoral Act 2022, he stated the position and intention of the legislature, particularly as it relates to the appropriate mode of transmission as well as transfer and collation of results. In rounding off the written address, the Obi petition Olanikbekun said, "I am concluding this address. May we draw your lordship's attention to the memorable pronouncement of the Supreme Court in Elias vs. Omobare 1982, 5 SC 13 at 22, where Udo Udoma, JSC, opened doors. If there was ever any cause or any case completely starved of evidence, this is certainly one. This case clearly cries to the high heavens in vain to be fed with relevant and admissible evidence. The appellant woefully failed to realize that judges do not act like the oracles of life, which are often engaged in clinical gazing and thereafter will proclaim a new Oba in succession to a deceased Oba. Judges cannot perform miracles in the handling of civil claims and least of all manufacture evidence for the purpose of assisting a plaintiff to win his case. In every material particular, the above except from the Supreme Court judgment describes this petition in very clear terms." And this is the final written address coming from Bola Ahmed Tinubu and Shettima addressing Peter Obi, Labour Party, Atiku Abubakar and PDP. This is literally all of it. If you have not seen the whole proceedings, please check our playlist how it all played out, especially that one that the last one that they brought in as their final witness, INEC PDP APC final witness, Senator Okpeyemi. That was an own goal if you ask me, but then again, that's their final written address. Let's meet in our comment section as we also await the reply from both Labour Party and PDP.